Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Each week, Joey answers your questions about the law and how it affects you.
What should I do if I get a DUI?
The first thing you need to do is sit down and write out an explanation of what happened, a statement, if you will, for your records. Because as time passes, you will forget the subtle details that will be very important to a DUI defense attorney. It's the absolute first thing you do. The day you walk out of the jail, you go to a coffee house with a notebook and you write out everything that you can remember, from the conditions of the road, to the time, to the weather, to the officer, to the test performed. Even if you don't know the name of the test, just describe them. And after that, you're going to need to contact a DUI defense attorney and set up an appointment to come in and speak with them. And you'll need to bring any and all paperwork that you received from the police department or the jail or your bondsman. That's always going to be the first steps whenever you are charged with a DUI.
Will I automatically lose my license with a DUI?
Only if you are found guilty of a DUI and you do not go the non-adjudication route. If you are found guilty of a DUI, you will lose your license for 120 days. There's no way around it other than non-adjudication. And there are certain requirements that must be met if you want to go the non-adjudication route. Not everybody qualifies for it. For example, a commercial truck driver would not qualify for non-adjudication.
Okay, so if my license is suspended, can I get a limited license so I can go to work?
The answer, unfortunately, in Mississippi is no, you cannot get a limited license if you are convicted or you plead guilty without the non-adjudication. However, I caveat that by saying that if you go the non-adjudication route, you can put a breathalyzer in your automobile, and every time you want to crank it, you have to blow in it, and it registers whether or not you have alcohol on your breath at that time. And that is the only way to get any kind of limited license, because you would actually have to surrender your normal driver's license and obtain a interlock restricted license, is what it is called, to operate an automobile under those circumstances. Otherwise, you would be charged with driving while your license is suspended.
Okay, that's good to know. Now, how long is my case going to take?
That varies from court to court usually, and it's kind of a complex question. If you're talking about from the date you're arrested to the date the trial occurs, if you tried at the lower court level, you're probably looking at a 3 to 4 month turnaround. That's the general time frame. However, there may be continuances involved. The state may ask for a continuance, which may be granted, which could extend it out another month or 2 months or 3 months. And in the event that you're doing an appeal or you plead nolo contendere, it's likely going to be extended out another 6 months in that area, because you're going to a whole different court and you're starting the process all over again. And to be honest, it varies from court to court because we're going on their calendar. I don't get to set it on my calendar. They tell us when they will hear it.
How long will a DUI be on my record?
As far as stacking DUIs, and when I say stacking DUIs, say you get a DUI first on January the 1st, 2017, and you get another DUI on December 31st, 2017. Well, those two DUIs are going to stack, and the second one will become a DUI second. However, if you got that DUI on January the 1st, 2017, and you got another DUI on January the 1st, 2025, then that 2025 DUI would also be a DUI first. And the reason behind that is generally they stay on your record for 5 years, and they don't completely go away in the sense that they're still there. You can still see that you were charged with a DUI, but at that point, it's no longer impacting your insurance. It's no longer impacting whether or not you get a second DUI. And you always have the option of expunging a DUI, again, if you meet certain requirements after 5 years, which would take it off of your record.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Call attorney Franks for a free consultation at 601-773-7777. His website is thefrankslawfirm.com.